This is K2 News at 6 on your side.
And she laughed. She said, "Come on, that's not abuse." I am a pretty strong girl, and that really shook me.
These three Oregon women say the Clackamas County District Attorney's Office and West Linn Police failed them and dozens of others. Tonight, they're opening up to KATU about alleged abuse at the hands of their doctor. In their frustration, he's not been charged. Thanks for joining us at 6. I'm Rick Asway. Deb Knapp and Steve Dunn have the night off. We do want to warn you, some of the details in this story may be disturbing to hear. A KATU investigation raises questions about the criminal investigation into David Farley. The district attorney tells me Oregon law prevents him from prosecuting the former doctor. This report from the Oregon Medical Board says Farley repeatedly violated the standards of care and the American Medical Association's Code of Medical Ethics. The women I spoke to say those findings prove Farley should be in prison. The DA sees it differently. David Farley is a Harvard-educated former physician. He lived and worked in West Linn for decades.
That is where we have the best results.
This video is from an unrelated story KATU did with him in 2016.
It's a really unique circumstance that's brought all of us together.
Nicole Snow, Katie Medley, and Lisa Pratt say he was a doctor they trusted.
Every time that we have a chance to really explain the things that Farley did, people are very confused why the police didn't take action.
Farley's medical career came crashing down in 2020. The Oregon Medical Board opened an investigation in August of that year. In his disciplinary notice in September, the Oregon Medical Board found Farley took pictures of, quote, the breasts and external genitalia of minor patients and said those pictures were for a medical study. Farley said he got consent but could not provide proof to the medical board. The board's investigator also found Farley performed pelvic exams and pap smears on minor patients beyond what was necessary. The board revoked his license in October of 2020. In its notice to issue discipline, it said his behavior, quote, constitutes unprofessional or dishonorable conduct and cited the willful performance of any surgical or medical treatment which is contrary to acceptable medical standards, sexual misconduct, and gross or repeated acts of negligence. Farley agreed to never reapply for a medical license in Oregon.
The Oregon State Medical Board, made up of 11 doctors, said that his conduct was sexual in nature. They said it was sexual misconduct, and they stripped him of his license. You would think that it would kind of be a slam dunk.
The medical board's findings detail minor patients of Farley's. These patients say he did many of the same things with them. They reported that behavior to West Linn Police. Katie Medley and Lisa Pratt even testified before a Clackamas County grand jury. That grand jury decided against criminal charges in September of this year.
And if there was more...
Clackamas County District Attorney John Wentworth says Farley's position as a doctor was too big a legal hurdle for the grand jury.
Our elected district attorney seems to think that when we walked in those doors that we consented to abuse, because those were his words. And that's why it was so hard to convict him. And he's wrong. He's just wrong. Nobody consents to abuse. And that message is so harmful.
Wentworth points to an exception in Oregon criminal law for medical procedures. That exception excuses penetration that is, quote, part of a medically recognized treatment or diagnostic procedure. It does not say anything about the procedure being medically necessary. And I just want to play this and then get your reaction on it. I showed Wentworth what Lisa Pratt said.
Our elected district attorney seems to think that when we walked in those doors that we consented to abuse, because those were his words.
Did they consent to that behavior? What's your take on that?
Well, the term abuse is defined in criminal law. And when the patients described the conduct to the grand jury that Dr. Farley engaged in, that's what they based their decision on. It wasn't just a term of abuse, which is a term of art in criminal law. What was the conduct that Dr. Farley engaged in? It's not walking through the door that gives someone consent. There was testimony, a lot of testimony, that Dr. Farley was open with his patients about the reasons he was doing the pelvic exams more frequently, the nature of the examinations he was providing. And so those are the issues that presented challenges to the grand jury.
The Oregon Medical Board found that Farley repeatedly violated the American Medical Association's Code of Ethics, standards of care, and further said that much of his behavior in question constituted sexual misconduct. If the medical board says these actions are not medically necessary, they're not medically recognized, why can you not pursue criminal charges?
The greatest challenge in this case is that point, that the conduct of Dr. Farley was unprofessional and it was outrageous, but not easily addressed by the criminal law in Oregon as we currently have it. That's the biggest challenge and probably the greatest part that's been underreported in this entire case.
It seems like the Oregon Medical Board set this on a tee and said, this is not medically recognized, therefore no exception here.
Well, I think that's a deeper reading of what the Oregon Medical Board is actually concluding. They address those issues through their administrative procedures. I have to address what is allowable or not allowable under Oregon criminal law.
Did you present the Oregon Medical Board findings to the grand jury?
We weren't allowed to, as a matter of evidence, present their conclusions. We presented much of the evidence the Oregon Medical Board relied upon to the grand jury for their review in the criminal realm.
Why can you not share the conclusions?
Because it's actually irrelevant under Oregon criminal law.
But if you're trying to prove that his behavior wasn't medically recognized, would you not need the medical board as the expert to say this is in fact not medically recognized? As a district attorney, you can't say that, but the medical board could.
But except it's hearsay. So presenting a report,
even though he admitted to it.
Even if, well, there's an exception for his admission, right? His conduct was reviewed by, we had two experts that we brought in. One was a professor from Oregon Health Sciences University with 42 years of clinical experience as an OBGYN to review his conduct, and we had a medical doctor who was a pediatric child abuse expert, one of only 350 in the entire country, come in and talk about the child aspect of this case. So the grand jury was able to hear the foundation or the facts that the Oregon Medical Board was aware of, as well as expert testimony in what that means.
Wentworth says he cannot tell me if the medical board's investigator testified due to state law sealing grand jury proceedings. Some of Farley's former patients say the grand jury got half the picture. Do you feel like you are being transparent? Because these women say they don't know who testified. Not all of them were called to testify. They feel like the process has not been that transparent.
Unfortunately, in Oregon, once there's a not true bill, it's very, very difficult to get access to the records that were presented to the grand jury, the information that was presented to the grand jury. The system, the criminal justice system, is intended to protect citizens from government overreaching, right? So that's Oregon's way of dealing with that. There's nothing I can do about that. I will say that prior to our bringing the case to grand jury, we reached out to the patient's attorneys and asked for any information that they thought we should present to the grand jury. They provided us with nothing. Before the conclusion of the grand jury, we reached out again to their attorneys, asked, we're about to conclude grand jury, is there anything else we should present? And they gave us nothing. If there are additional witnesses out there who might come forward and be willing to take this case and open the case back up for grand jury, we're more than willing to do that. But we went forward with the evidence that we had.
The women's attorneys say they shared everything they had and held nothing back. Attorneys for Farley's former patients simply believe in this case that the facts are sufficient for prosecution. At the end of the day, why do you not necessarily agree, and why do you think the grand jury didn't agree?
Well, respectfully, none of the plaintiff's attorneys in this case are experts in criminal law. That's my expertise.
Wentworth also denies allegations his office mistreated Farley's former patients. I'll give you a specific example. One of these former patients says that she told Sarah DeMont that David Farley performed a pelvic exam without a glove. This woman says that Sarah scoffed and laughed and said, come on, that's not sexual abuse.
When we are dealing with such hot or emotional topics, such as alleged sexual abuse, things that are said and things that are heard can be misinterpreted. I don't know whether that's what happened here. What I can assure you is that my staff acted professionally and with compassion throughout this case.
Despite the grand jury's conclusion, these women say they won't stop until Farley is prosecuted. They're asking the Oregon Attorney General to review the case. The AG's office has not decided if it will do so.
All we have to hold on to is hope at this point, and I can only hope that that happens, because people can't abuse women. It is so wrong, and that's the reason why at this point we're still fighting, because we're hopeful that, since we've seen it happen before in the past, that the Department of Justice and the Attorney General's office will hopefully get involved and do the right thing here.
It doesn't always end up this way. Doctors accused of abuse in other states have been prosecuted successfully. There's a lot more to this story. Coming up in another special report soon, we're looking at the differences in state laws. Wentworth says the case exposes a gap in Oregon. As for former Dr. Farley, I reached out to his attorney of record on numerous occasions via email and phone. We have yet to hear back.